Committee on COVID-19. This morning we are meeting to discuss the Gauteng High Court Department, who has prepared a legal note for us, which has been distributed to members. But before we get on to that, I'd like to introduce myself. My name is Mireille Wenger, and I'm the chairperson of this ad hoc committee. I believe we are quorate. We have received apologies from Honourable Bartman, who is a special delegate to the NCOP this morning, and Honourable Mackenzie is standing in for her as the permanent member. And we have also received an apology from Honourable Syed. Are there any further apologies? Any further apologies? None. Thank you very much. Just in terms of the usual rules of engagement for virtual meetings, all members are muted at the beginning of the meeting to avoid background noise. Members should please flag points of order using the chat function or by using the raise your hand button. All video and audio should please be switched off to improve the quality of the connection. However, if a member, minister, HOD or official is presenting or speaking, they should obviously please put on their microphone and their camera. And once they have concluded their inputs, if they would then turn off their video and mic. We also ask that presenters unshare the presentation once the briefing has concluded. With that as the introduction, good morning, Advocate Marsdorp. Thank you for joining our meeting. And thank you very much for having prepared the legal note. I thought the way that we could proceed would be for you to just give us a brief overview of the note, and then members will pose some questions of clarity for those things that might not be clear. So with that being said, then may I hand over to you?
Certainly. Certainly, Chair, that's not a problem. Thank you very much. Good morning to you and to all the members as well. I will assume, Chair, that the members have read the note, so that I will not necessarily give the kind of, if you like, detail that's in the note, except to say the following, that the court order, because I was asked to give an overview of the implications of the judgment on the WCPP and in particular its COVID committee. So the implications, not to give a summary of the judgment, but the implications of it. And the implications are very much summarized in the first few lines of my note. And I will read it so that it, at least to that extent, is complete. The first implication is that the regulations, those that were placed before the court, by the way, have been declared unconstitutional and invalid. Further, that declaration, that court order, which in fact declared those regulations invalid because it's unconstitutional, that declaration has been suspended. And it's been suspended, as is often the case, in order for the executive, the minister in this instance, to make amends so that the regulations become consistent with the Constitution. And that suspension has been extended for 14 days or for such longer time as the court may deem it necessary. So that just as a backdrop. The implications of that, Chair, is that until such time as the expiration of the 14 days, or until such time as the expiration of any longer time thereafter, or until this expiration of a possible appeal has been heard, that regulations emanating from the level 3 regulations remain in place, remain live, remain effective, to which we should subscribe. So what has happened is, since this note was written, by the way, is that I believe that the government has indeed lodged an appeal. As to when that appeal will be heard, I'm not too sure. This is subject to court rules and degrees of urgency that will be given to it. But until such time, what is relevant to us as an institution and our committees is that the regulations pertaining to level 3 do still apply, and to which we should subscribe. Like I said, in short, that in summary, except for the other detail that is in the note that I wrote, Chair. In addition, I've also raised the issue pertaining to the NCOP's role, and I think the note is very clear in that regard. So unless there's questions specifically pertaining to that, then we can certainly discuss that. Thank you, Chair.
Thank you very much, Advocate Marstorp, for taking us through that note, which members have received and I'm sure have read. We're not going to do the usual per party question period. It will just be an open session. So if anybody would like to pose questions of clarity, if they would raise their hands. If I could just ask Advocate Marstorp, I've read that the government intended to appeal the judgment. However, I haven't seen any confirmation that that has in fact happened. Do you know whether it has in fact been appealed?
Chair, and I can only go on newspaper reports to this effect. I believe that they have submitted their papers on Tuesday, day before yesterday, yes, setting out the grounds for their appeal, yes.
Okay, so in effect, that means that the current regulations remain in effect until the court makes any further decision.
The Constitutional Court, that's right, yeah.
Okay. Thank you. Members, are there any questions of clarity? Okay. Any further questions of clarity? Okay. Advocate Marstorp, do we have any indication of whether this will be heard urgently, or what would be a timeline that one would expect for this process?
I would love to have been able to tell you, but I'm very remote from those processes. As I said earlier, one should of course submit an appeal within a certain prescribed period. That has now been done. It's now subject to the court role, and literally, at least if one should, for example, look at the processes in the High Court, there's a registrar which allocates courts to matters and judges to matters. In this instance, it's very much intra-constitutional court dynamics which will now kick in. I'm sure that the officials there and the relevant presiding officers will give due consideration to the urgency and the need for legal clarity in this regard. So the urgency will certainly be a decisive factor to allocate a court date over other matters which may have been allocated dates already.
Thank you. And given the President's announcements last night, we can expect, I assume, a new round of regulations to be published. Then should those regulations address some of the concerns of the court, would then this appeal become an academic exercise?
Most likely, because it will give a retrospective view on the constitutionality or otherwise of regulations as passed during or in anticipation of level 4. The relaxation, if you like, that was articulated yesterday by the President pertained to regulations level 3 and what has now been dubbed Advanced Regulation 3, or level 3 rather. So it will largely, yes, be an academic exercise, a necessary one, because in the De Beer judgment, there's been some, with respect to the presiding officer there's been some legal faux pas, if you like, in terms of the application of certain principles and the confusion of the legality, the confusion of the rationality test with reasonableness, etc. So the court, the Constitutional Court, that is, will certainly give emphatic underscoring, if you like, of those tests, how it should be applied, and that the Judge Davids in the De Beer matter may have, and by all accounts has in fact, applied the legal test wrongly when he considered the constitutionality or otherwise of the regulations. So it will largely be an academic exercise, but a necessary one, so that we can get legal clarity on a number of things.
And then I also assume that, you know, for certain regulations for citizens that were arrested or fined in terms of those regulations, if those are then declared to be unconstitutional, whether those citizens will have any kind of recourse.
Chair, let me give a high view. I would hate to be in a position to give legal advice on specific instances of arrest, but let me give the higher level view. If someone has been arrested for having contravened particular regulations and the provisions of those regulations, that arrest stands. However, if subsequent to that, the provisions or the legal framework which gave grounds for that arrest is now deemed to be unconstitutional, that will certainly, if you like, absolve that person, and there will certainly be recourse for the arrestee, if you like.
Thank you very much for that, Advocate Marstorp. I see we have a question from Honourable van der Westhuizen.
Yes, thank you, Chair. In a sense, you touched on what I wanted to ask, and that is regarding the fines that people have paid. Perhaps Advocate Marstorp can just assist us. Apparently, there's a difference between these, and I don't know if it's an admission of guilt fines that people have paid, and the kind of traffic fine that one sometimes encounters as well. So, is it true that if you have been fined and you've just settled this fine within this period, that you have admitted to guilt, and that therefore, technically speaking, you will now have a criminal record? I'm not certain, and I would appreciate it if Advocate Marstorp could give us and the members of the public some guidance in this regard. My impression is then that at this time, should people be fined for walking on a beach or something like that, that they should not admit to guilt. What should be the position in this regard?
Chair, I'm not sure if I understand the question correctly. My understanding, and kindly guide me if I'm wrong, my understanding from the question is that if there is someone who was arrested and that person has subsequent to the arrest pleaded guilty, and as a result of that plea has paid a fine, whether that should stand still in anticipation of the appeal. I'm trying to make the connection between the question and the pending appeal and the court judgment, if the member with respect can maybe just guide me with more clarity in that regard.
Yes, thank you. So should such a member of the public now say, well, I'm not going to settle this fine within 14 days or 21 days, I presume there is a time limit to this process. What must a member of the public now do? Should they be stopped at the roadblock and fined, or, as I've said, walk on a beach and be fined? What is the legal position?
Chair, I think I
Yes.
understand it now.
Okay.
Let me put the following out there. There is no legal vacuum. The De Beer judgment declared certain regulations unconstitutional and therefore invalid. The De Beer judgment gave the government 14 days to make amends. The De Beer judgment said until such time regulations have been amended, the law will remain the same in terms of regulation passed during level 3. There's no vacuum. We don't have a legal hollowness, if you like. The law continues, the regulations in level 5 are live. If someone has committed a wrong in the sense of violating the provisions of regulations, the law will apply. If and when a constitutional court has given finality, conclusive clarity on the regulations pertaining to level 4, by the way, because level 3 still applies. If the court, constitutional court that is, gives finality on level 4, it will be academic. But the court, the constitutional court will hear this matter while level 3 is still live. The law will continue to operate. We're not living in a legal vacuum, if you like. So the question baffles me somewhat because there's no uncertainty as to what the law is. The law is level 3 regulations. In fact, not just level 3, a new level 3, if we are mindful of what the President said last night. People must pay their fines. If people violate the law, they must be arrested and dealt with. There's no gap to be taken because there's a constitutional court appeal pending. The law is alive and active and effective and applicable.
Thank you, Honourable Heron.
Thanks, Chairperson. I actually just wanted to make the point that I think it's inappropriate for us to ask Advocate Marsdorp to be giving legal advice as to what individuals must do if they are faced with a law enforcement or police officer saying they contravene the regulations. I mean, as the advocate says, the regulations are still stand. If I recall, maybe this is where Advocate Marsdorp can clarify. The judgment didn't specify which regulations were unconstitutional and which were constitutional. And as he rightly says, the judgment has been widely condemned as probably going to appealable, and that the judge confused different legal principles. So I think there are some people who have embraced this judgment with a lot of glee, and I think it's inappropriate for us to ask Advocate Marsdorp to now advise individuals or people who are listening to this whether they can avoid paying a fine or step on a beach, because all of those regulations still stand until they're amended, and none of the judgment didn't actually specify which regulations he regarded as unconstitutional. So I'm just asking that we allow Advocate Marsdorp to brief us without asking him to give legal advice in this manner. Thank you.
If I could maybe just latch onto that, Chair, with respect, if you don't mind me just barging in.
So please proceed.
Just to latch on the issue which Member Heron has mentioned now, and I think it's a relatively profound observation to make, which he has touched on now, and that is the following. An applicant goes to court and asks the court to declare certain and to ask the court to declare the regulations. Take note, the regulations unconstitutional because those regulations do not comply with the provisions of Section 36 of the Constitution. In other words, the Bill of Rights, or rather that with the statute of limitations, sorry. The regulations do not comply with the provisions of the Bill of Rights in as far as limiting of rights is concerned. This matter was heard during level 4 regulations. In fact, on the eve of level 3, a few days after the court was sitting, level 3 kicked in. The judgment was given subsequent to when level 3 was effective. But what the court did was to, and let me just pause here. When you submit, when you initiate the court application, Chair, the applicant and whoever is in support of the matter submits affidavits which disclose the legal basis for their court action. It submits affidavits, and the application is heard by the court off the papers in front of the court. In other words, of the affidavits that were submitted to the courts. And these affidavits disclose the legal basis, legal argument that the applicant makes. As happens in court proceedings, we've got a beautiful principle called audi alteram partem, which means hear the other side. So when I go to court as an applicant, I submit my papers, my affidavits. That affidavit and those papers must also be submitted, this is how the court works, to a party who will most likely oppose it. In this instance, the minister, the executive, the government. Government is then given an opportunity to respond to the averment made in the papers by the applicant. When the matter comes before the court then is beautifully confronted with the applicant's view of the law and the application and interpretation thereof. The court is also equally seized with the response by the respondent to that application and the averments made in the applicant's affidavit. So the judgment can then only be within the confines of those affidavits. In other words, the judgment of a court can only be on those matters placed on the papers before the court. This matter was heard during level 4 and the applicable regulations. On the eve of level 3, when the judgment came out, we were already in level 3. What the court did was to also consider the regulations of level 3 and to also cast a view, a judgmental view of those regulations and its constitutionality or otherwise. The court strayed outside of its lane. It went beyond what is called, it went beyond the papers before it. What does that mean? What's the implication of a court having done that? Imagine I go to court as an applicant and I say to the court, listen here, deal with the following matter because this is what I believe the law is. That affidavit is then given to the respondent to respond to that. The respondent then responds to what I have said in my affidavit, in my application. But the court makes findings on matters to which I have not responded because it was not in, because the only things that were in the affidavit of the applicant was level 4, not level 3. What this court has done, has gravely done, was to pass a judgment on matters which the minister has not spoken to, because level 3 was not raised in the applicant's application. Level 4 was raised. The government is now saddled with a judgment against it on matters which it has had not an opportunity to respond to. So this judgment was flawed. Off the papers already, it was flawed. I'm not even talking about the application of the rationality test principle and compared to the reasonableness principle. So there's a very good likelihood, a very probable outcome will be that the judgment will be overturned in many respects. And even more, listen to this, Chair. The applicant raised the constitutionality issues insofar as it pertains to the Bill of Rights and the limitation of rights. This court, this High Court, Judge Davis, dealt with certain regulations. In fact, the judge highlighted in relative detail what he feels is the basis for the irrationality and the arbitrariness of these regulations, which he highlights. And he gives what is regarded as inadequate reasons for his thinking. But the judge does not declare those particular regulations invalid. He uses those few which he has highlighted as a basis to declare everything unconstitutional. With respect, I am no judge. It's an aspiration of mine. But that's not how courts work. You give reasons for your thinking. Ratio decidendi. There's a principle in this regard. Reasons for your decision. The judge strayed outside of his lane by giving judgment on matters not in front of him and by giving judgment on matters which he himself has not duly considered. He did not give reasons for a blanket ban on level 4 regulations. He may have given reasons for some of the regulations he himself has highlighted. Although those very reasons are perceived to be flimsy and inadequate, he has strayed beyond what was competent for him to do. Thank you, Chair.
Thank you, Advocate Marsdorp. I'm also mindful of our standing rules that do not allow us to reflect on the competence of officers of courts. So I think we should stop there. Honourable Heron, is that another question or is that your hand from your previous input?
Sorry, it's my hand. I'll take it down.
Right, if there are no further questions of clarity, then I think we could probably move on to the next item on the agenda. I see Honourable Murray is not present, unfortunately, as he had quite a number of questions on the NCOP part of the query. However, that would then be, I suppose, a missed opportunity.
Chair, if I may interpose, if you don't mind. Yes. I'm not sure, like I said earlier, my note as far as this is concerned, the NCOP issue, is short and relatively clear, if I may say it myself. But if there's questions in that regard, then from any other member, I would certainly deal with that as well. Let me, just for the record, then just say the following, and I hope I'm not being indulgent here by stealing your time to speak about this when you didn't ask me to. But since you raised the issue, it is also very much a live one. We know that the Act, the Disaster Management Act, provides for the minister to make regulations. And the minister may make regulations in respect of certain instances. Those instances have been listed in the Act, Section 27, if I remember correctly. And if one looks at what those instances are, where the minister may make regulations, then one will see that those instances, let's call it functional areas, they fall what largely correlates to the provision, the functional areas in Schedule 5 of the Constitution. And Schedule 5 speaks to provincial legislative competence. So the minister may make regulations pertaining to functional areas which relate to provincial competence. Now, how is that? Hence the issue and the relevance, that is, of the NCOP. And this is where I think the judge, in the judgment of De Beer, was very astute and very circumscribed. I think it was a good view on how we interpreted the Disaster Management Act in relation to the NCOP's role. I don't have my notes in front of me now, but from what I recall, it is the following. The minister may make regulations pertaining to certain functional areas, and it so happened that those areas coincide with Schedule 5, which pertains to provincial legislative competence. That's the basis. There are instances provided for in section 59.4, if I remember correctly, of the Disaster Management Act. And that section says that if a minister makes regulations pertaining to issues provided for in section 59.1, then those regulations must go to the NCOP. And if I remember correctly, I think 59.1 pertained to matters of the appropriation of monies from Parliament, monies which may need to be paid for emergency, or for people who may have been injured during a disaster, etc. In other words, less of, if you like, an urgency. And this is where the judge, I think, got it right in the distinction that he drew by looking at the text of the Disaster Management Act. So what we have is the Act says, if the minister wants to make regulations pertaining to matters provided for in section 59.1, then section 59.4 says, in those instances, the NCOP must give prior approval. That's a very express and a deliberately expressed provision in the Disaster Management Act. The judge very prudently draws the inference that in the absence of such an express provision, all other regulations may be made by the minister without the prior approval of the NCOP. And the judge gives reasons for that inference to be a reasonable inference. He says, and I agree with that why there's no express compulsion for the NCOP to be part of the section 27.1 regulations is because of the inherent urgency that is prevalent when section 71 decisions and regulations are made. Because he says, and I agree with him, that if one should compel a prior NCOP approval for all regulations, one would negate the primary purpose as far as disaster management is concerned of regulations to serve as interventions, urgent interventions to augment where current prevailing legislation is not sufficient to provide for and counter and mitigate disasters. That would be the reason for urgency. So there's a very beautifully articulated part of the judgment by the judge to distinguish between the need for NCOP prior approval and where the Act in its text as well as in its context provides for no need for prior approval for NCOP legislation. Thank you, Chair.
Thank you, Advocate Marstorp. Are there any questions of clarity on that input? None? All right, thank you very much, Advocate. Thank you very much for being with us today and for providing us with that note, and as well as answering our questions.
Thank you, Chair.
Thank you. On that note, then, members, we're going to move to the next part of our meeting, which is to finalise the public participation and the questions that we want to put out as part of that public participation process. So we can finalise those, and then we have a set of minutes that we need to consider. All right. So in our last meetings, we decided that that we were going to go with a question, an overarching question, which is what is your experience of government during the COVID-19 pandemic? And then a set of sub-questions which would distill a lived experiences. That's not the right document. I mean, it's the same information, but in a different format. Thanks. So basically, the questions would be related to the themes of the committee, but distill in a way, would be distilled into a question that is a lived experience. And we would then ask residents of the province to, through WhatsApp or email or voice notes, provide their, give us their view on how government is managing the pandemic. So this is then the proposal. If Lizette, if you could beam up that document. So that it would have two prongs. So first, let me say that the adverts would be done in all three languages of the Western Cape, in English, Afrikaans and Xhosa. We would then have two prongs. The one would be through the formal media, which would look something along those lines. And we'll discuss the questions themselves in a minute, so it would have the overarching question of what is your experience of government during the COVID-19 pandemic, with some sub-questions to help guide, but members of the public could give us their input on anything really. And then what we would do is, for social media, is take each individual question and put it into an infographic. So it would be, have your say, what is your experience of government during the pandemic? And then question 1 would be one little infographic, and question 2 would be an infographic, and so on. I'm advised that we should try and, limit the number of questions so that it's not, overwhelming with too many infographics. We would then distribute that to members to be able to put on your networks as well, to try and get the message out as far and wide so that we can engage with as many people as possible. So that's then the two prongs, the one through the formal media with one advert with everything together, and then the social media prong, which would split the questions up into individual infographics, as it were. Okay, so with that being said, this is some of the thoughts for the questions that, for example, relate to are the regulations being followed for public transport? So by asking the question, does the public transport you use have masks and sanitizers? It would ask questions about the public information campaigns and the work of the Department of Health, by asking, do you understand why you need to wear a mask? Were you able to access food support when you needed it? That would talk to the food security element that we've been looking at. Did you feel safe when you went back to work? That would talk to the whole element of, the COVID occupational health and safety. Is your child's school practicing social distancing and temperature checks every day? And then what are your thoughts on the opening of ECD centres? And then share your experiences and thoughts with the Provincial Parliament through, and then all the different contact avenues. So members, do you have any thoughts? Do you like the concept? Are there any questions that you'd like to add or subtract or edit, put in a slightly different way? So that, ideally we can well, we must finalize it today so that we can get the program running in the next 3 weeks while we're on our constituency period, so that we can then consider them on our return. Honourable Heron.
Thanks, Chairperson. I was wondering if there shouldn't be maybe 2 kinds of chains of questions, kind of those, were you, because these questions do not really get to the heart of how those who were impacted directly by this virus, either because they were tested positive or they were close contact, how they experienced government having been really exposed to the virus. So I was wondering if there wouldn't be more appropriate to start off by asking that kind of question. Were you exposed to the virus? If yes, then he has a whole lot of questions for you, which talk about were you able to isolate? Were you offered a space in a public facility? What kind of support you were offered? And then the other, if you say no, then these kinds of questions, which are really about being an observer in a space of a pandemic, not really being someone who's exposed to it, whether you felt safe, whether you know how to wear a mask, all of those questions are appropriate. But I don't think we're asking any questions about to those who were directly exposed to the virus and how they felt supported by government.
So what if we were to say, if you were exposed to the virus, share your experience of the health system? That would then leave the person to tell us if they had problems with, being followed up, or their test results, the care that they got, etc.
Well, can we, if I may, Chairperson, can we not put those questions in? If you were exposed to the virus, were you tested, private or public facility? How quick did you get your results? Were you offered, did you go into isolation? Did you self-quarantine? If not, why not? I mean, I think those are important things to understand, and to actually prompt people to answer specific questions about how they changed their behavior. Did they isolate? Were they able to isolate? If they were not able to isolate, were they offered a facility, a public facility? Were they symptomatic? I mean, I think we could actually get a lot more valuable information if we pose those questions.
So the thing is, what you're describing is a questionnaire, this isn't really a questionnaire in itself. It's we're asking for inputs on how government has been performing in members of the public's view. So if we were to go that route, we'd have to have then, I think, a different set of questions specifically for that, because otherwise it's too many. It's going to be too many questions that we won't be able to put into this format, if I can explain it in that way. So I mean, what we could do is one set of one whole infographic on just those items. That's one way we could do it. But for the purpose of the general advert with the list of questions, we could just have the more generic, if you were exposed to the virus, please, share your experience of the health system. And then in the infographic, we could have it more detailed, and have the issues of were you traced, were you isolated, how long did it take to get your test results, etc. That's one way we could do it. Honourable Mackenzie.
You covered me partly, because when I go to shopping centres and they have this long questionnaire, more than 10, 15 questions, it becomes tedious and I just walk away.
Yeah. So, okay, so
come in?
Yes.
Yeah, so I mean, I think if we're going to do infographics, you could, I mean, you've already got 6 questions here which look like a questionnaire anyway. So I think it would be a meaningless exercise unless we do ask people who were exposed to the virus to also share their experience about how the health system responded to them. I don't have it. I think the way you proposed it, of having the advert really posing it in 2 ways, and then the infographics asking maybe specific questions, not necessarily as questions, but prompts as to how you could maybe respond to
yes, exactly.
information we need.
That's exactly right. So these are prompts rather than a questionnaire. So can we then agree we will do it in that way? So the what you're seeing now is the overall advert. So we will add another question to it, which would be, if you were exposed to the virus, please share your experience of the health system. And then when we go to the infographic for that particular question, we will add additional questions. How long did it take to get test results? Were you able to isolate? Did you end up in hospital, etc.? Anything further, Honourable Heron?
I think that's perfect. Thank you so much.
Okay. Perfect. So then that particular infographic will contain further prompts in that respect. Honourable van der Westhuizen, and then Honourable Christians.
Thank you, Chair. So would we be able to say these are some topics that you may want to refer to? So it's an open invitation. We're just prompting people to expand or to comment on certain aspects.
Okay, I think that's very helpful. So if we could say, what is your experience of government during the COVID pandemic? And then underneath say, for example, and then list the questions.
Agreed.
Thank you. Honourable Christians.
Thank you, Chair. Just with what you're proposing, just say, were you or a family member? Because when people are affected, then they will respond to all these questions. But if you feel I'm not part of that, then there might be loved ones that lost their family members and they cannot speak. So you or a family member, and just put, because they can speak on behalf of people that lost their lives and maybe did not get the assistance. So I just want to throw that in. Thank you, Chair.
Thank you. I think that's very helpful. We will include that. Were you or a family member exposed to the virus? And then we will add that question underneath the, we can add it as the first question or the last question, whatever it might be. And then we'll just make it clear that for the infographic, it will have those additional sub-questions. Any further inputs? None. Okay. Can we then approve this?
Agreed.
Yes, we can.
Agreed.
Thank you very much, members. Right, so we will then put those into the WCPP format. We will get the adverts going in the formal media in all 3 languages, and then also have those infographics made also in all 3 languages, which will then be distributed through the WCPP channels, and for members it will be put on the WhatsApp group so that each committee member can also spread the word, as it were. Then when we return, we have our public engagement program, which you've all seen, which will include engagement with the private hospitals, with hospital boards, chambers of commerce, with school governing bodies, with survivors of COVID-19, etc. And then we will then review all of that with the grid of submissions that we receive from this. And then we will have a discussion on potential public hearings, which will be we'll have that discussion towards the end of August. Okay, thank you very much for that. We then just have one set of minutes that if we could adopt this morning. I think that they might have been distributed, but that was only this morning. So if with members' permission, can we consider them now? And I'll just give members time to read them. They're not very long. That was from our meeting last week, the 10th of June, with the Department of Health briefing. So those are the attendance register. Any edits or amendments to page 1? No, let's move on to page 2, sticking with the attendance. Okay, and then present in the meeting. Okay, let's stop there. Any edits or amendments to page 2? Okay, let's move on to page 3, the first paragraph.
Chairperson, I propose that we adopt the minutes. It's Gideon Bosman.
Thank you, Honourable Bosman. Can I have a seconder?
Support.
Thank you, Honourable van der Westhuizen, and the minutes are then adopted. Thank you very much. Then finally, I've just been prompted by the our procedural officer. Thank you very much, Ms. Adams. Are there any particular newspapers that members would like us to advertise in? Honourable Bosman.
Chair, I think I'd like the committee to consider us using not just metro-based restaurants, newspapers, sorry, but also a newspaper in the rural areas. So perhaps the George Herald in the Southern Cape would be useful. That would be my suggestion.
Thank you, Honourable Botha.
Thank you, Chairperson. I second that proposal and want to add the Courant on the West Coast as well as the Westlander.
Thank you very much. Any further suggestions, Honourable van der Westhuizen?
Thank you, Chair. Can we decide to leave this to you, subject to the available budget for public participation? Because I'm concerned that we are listing certain regional newspapers, but I think we need to consider a fuller list of newspapers should the budget allow for that. Thank you.
Thank you. So we will, we'll advertise in the sort of main English, Afrikaans and Xhosa papers, as well as being mindful that we have coverage over the entire province in the metro as well as in the rural areas. Is everyone satisfied with that?
Yes, ma'am.
Yes.
Thank you.
Okay. Chair, yes.
Super. Thank you very much. Then I think, let me just check. I think that then concludes the items for today. Thank you very much all for your participation in the committee today. And I'd also like to thank our procedural officers, our senior Ms. Klitter and Ms. Adams for their support to this committee over the last few weeks and for preparing all the documents. We'd like to say thank you to them. We will then see you on the 15th of July with the presentation from the Department of Health. So until we meet again, I wish you all to stay safe and healthy. Thank you very much, members, to you for your support, and thank you, Advocate Marstorp, for your contributions today. And with that, the meeting is adjourned.
Do you do, Chair? Thanks a lot.
Yes.
Thank
you,
you.
Chair.
Bye.